And she's like, there's a gizzard eating contest, my husband loves like fried gizzards, and I'm like, I'm not like the biggest fan of it. Just it's not my thing.
Well, we're gonna take care of another case.
Okay, sorry.
They have a testicle festival for mountain oysters in a little city in Lenawee County. What?
The male doesn't have a shirt on.
Yvonne Spangler was like,
Stacy, can you hear me?
Yeah, I can hear you.
Who do you have with you?
Jeff.
kids.
Mr. Brown.
Oh, Jeff, put a shirt on.
Apologize, sir. I didn't realize we were live.
All right. Well, Christine, why don't you go ahead? I'll bring your client in, Lisa. We've had kind of a fitful afternoon with fits and starts, and I guess we'll have another one. This case is entitled MLJL LLC versus Timothy Wayne Pelfrey. And Stacy, I apologize once again to Stacy Pantong as defendants. They are occupants of a 309 South Constantine Street, apartment 3. They kind of inherited it from someone else who inherited it from someone else. And the owner of the property wants them to move. Apparently no rent has been paid since maybe April or even earlier than that. Ms. Atzapantong, have you made any effort to find a place to live?
Yeah, I have been. I've been constantly. I've even went to different cities and different towns I've never lived in before, so I'm trying my best.
All right, well, you have until the 26th. You get 2 extra days of June to move, or you're subject to being evicted.
Okay.
Christine, I don't know if I have a judgment. Oh, here, yes, I do. You guys are what's called tenants at sufferance, and Mr. Brown doesn't live there, but he's there trying to assist you. But I don't, it just is what it is. Notice to quit was filed. We waited the appropriate time. We adjourned the matter for 11 days or 9 days, and the plaintiff still wants the property back. Mr. Pelfrey would be a default, but he's gone.
Yeah.
Well, and he's in
uh,
custody, Your Honor, right now too, so,
yes.
No,
yeah.
he's not. It was a different Timothy Pelfrey that got arrested.
Okay.
I thought it was him
We
too.
do have some concern, Your Honor, if Miss I can't pronounce her name, Stacy. If she would like to have notification, because we've having some issues. It appears that somebody new is living there now, and also there's a big dog that's there, and there's been cameras put to monitor and a baby to monitor the other tenants, and we don't want to lose the other at this point.
I have baby monitors on the outside of our apartment door, not of anybody else's door, because I was assaulted. That's it.
Mr. Brown, are you living there also?
No, sir, I am not. I've gone over and helped, and I've done repairs over there when the landlords have refused to. And I'm the one that put the new digital lock on there and never asked for a penny back in compensation.
Well, you can't do that. You can't change the locks.
You can when when it's been broken into and you need to secure it, sir.
No, you can't.
It can.
You get the landlord to do it anyway, Stacy. You've got until the 26th. We've got Timothy James Pelfrey is the one in jail.
Okay.
Timothy Wayne Pelfrey is the one that is at issue here. And so he's lists 309 South Constantine is his address, and he's no longer there. So the Timothy Pelfrey in jail is not this one.
Thank you for checking on that for us, Your Honor.
All right, Ms. Atzapantong, you have until Monday, June 26th to vacate, or you're subject to being evicted. Don't make any other alterations. Don't change any locks. Don't put up any cameras. Don't certainly bring in any pets.
I haven't had any pets and nobody else is living there, sir.
All right, very good. Then just keep it that way and hopefully you can get out of here in the next 12 days. If not, Sergeant Morse will probably be at the door that day with a writ of eviction.
Okay.
All right, do you have any questions?
No.
All right, you get 2 extra days, which is better than a poke in the eye. We actually adjourned this 9 rather than 7. But it is what it is. You're in there, you don't have a lease, you're not paying rent, and you need to go. All right, I will send you a copy of that order. And Christine, that takes care of both of your matters. Oh, we didn't actually go on the record, I don't think, with Shup. So in file 23584LT, the defendant failed to appear at 3 o'clock. It's now 3:12. He still hasn't appeared. And I've done a default judgment with the date for the writ and the appeal as 6/26. All right, Christine, thank you. I'll see you soon.
Thank you, Your Honor.
Ms. Wilkins, you're good to go. And Stacy, good luck.
Thank you.
Thank you.
All right, this is file 23499LT, Riverside Townhouses versus Amanda Smeltzer. Why don't you lawyers first go and place your appearance on the record. Ms. Zanin, go ahead.
Carrie Zanin, P67390, on behalf of plaintiff, Your Honor.
Ms. Bauer?
Attorney Meg Bauer, P84816, appearing on behalf of defendant Amanda Smeltzer.
Ms. Smeltzer, can you hear us?
Yes.
All right, this matter was set for a bench trial at 1:15 on a termination of tenancy filed by the plaintiff. We've been here on several different occasions. We were here on May 8th, May 15th, May 22nd. Each of those dates, the parties made substantial efforts to try to resolve the case, but never were able to quite get to the finish line. So I scheduled the matter for a bench trial today. There was a jury trial set for this morning that settled, and I was hopeful that it would settle, so I put this in for the afternoon. Parties have been working now for more than 2 hours trying to get to that finish line. Ms. Zanin, I'll defer to you. What's the status here?
We've actually agreed to a conditional dismissal with terms, multiple terms. We don't have it drafted, Judge, so we would just, I would ask for a control date just so that we can prep the documentation. I think that we're all on the same page as to the terms. We just need to put it in writing.
Well, let's get as close as we can here on the record. Do you wish to state the terms?
I can state the terms. Do you have?
Oh,
You want to say?
I can say the terms.
All
Yeah,
right.
you have my form too.
Or do I?
I think I gave it to you.
Not gonna lie, it's in the file somewhere.
It's okay.
Would you use the podium? That way that camera will be focused on you and we'll be making a better record. Thank you.
Judge, the parties have agreed to enter a conditional dismissal under Michigan Court Rule 2.602C, wherein with an affidavit of default, the defendant will have 14 days to object, file a verified objection, and schedule for hearing on the substantive allegations. The terms of the agreement are that Ms. Smeltzer will not have another lease violation for an unauthorized animal on the property. She will not have another lease violation for tampering or for removing her smoke detectors. She will not have another lease violation for making unauthorized repairs to the apartment. She will not have another lease violation for any unnecessary police activity at the unit for 6 months. Furthermore,
Just a minute.
yes, Your Honor.
That's kind of a vague word, unnecessary, but
We had a feeling this was gonna be.
depending on unnecessary who, but, go ahead.
The purpose being to enable Ms. Smelter to be able to preserve herself, protect herself. And if there's need for a substantive hearing on that, we'll cross that.
Yeah,
The parties
Judge,
agreed we'd cross that
Well-
bridge.
I think safety was it?
Well, there were two, Mr. Christ and Mr. Jones.
And, yeah,
And, they both claimed she let him come back at various times. So one option is don't invite Mr. Jones or, Mr. Chris to come back for any purpose. Then if they are there, they won't have that defense. But Mr. Chris said he'd actually been staying there, according to the pleadings and what he told me when I had the criminal case. All right, so we'll just leave it as unnecessary. What else?
We didn't want to go into
We
the
didn't
rabbit
wanna-
hole of
yeah,
domestic
just we-
violence and cycles of violence.
Well, and I certainly am well versed in the cycle of domestic violence, and there is a very strong aspect to this, particularly with Mr. Jones. But in either case, so you take all that aside, all the elements that you just listed would have been sufficient to terminate this tenancy. Disconnecting the smoke detectors, making unauthorized repairs with lottery tickets for masking tape, making repairs like the toilet or the furnace. Any of those things would have been sufficient to terminate the tenancy. The other issues regarding the men and those other incidents and the police calls, she's got a Violence Against Women Act defense to those claims, but not the others. But I guess I agree. Let's not go down the rabbit hole. If we're going to save this lady's tenancy, then
There's one more term of
All
the
right.
agreement. That is that Ms. Smeltzer agrees that she will not have two or more violations for the same allegation in that 6-month period.
say that again.
She will not have two or more lease violations for the same allegation. So for example, one violation for having, just to use the example we were using in negotiations, having a charcoal grill on her porch is against the rules.
something new, Judge, something that was.
Well, she had a couch on her porch. She had a charcoal grill
She
on her
did.
porch. She had other, dirty.
Your Honor, I believe the
Stuff.
couch is the one that was covered in gasoline by Mr. Jones when he tried to start her on fire.
All right, well, probably shouldn't have been there in the first place, but yeah, not a good. So she gets one bite of the apple and then the second one is,
Then I can file a reinstatement,
okay,
yes, Judge. For something new, yes.
okay. How
And
about
effort
no
to-
unauthorized tenants or occupants?
That hasn't been raised as an issue, and if there is an issue with that, then that would be a lease violation. And the terms that we've worked out have been the balance of the due process protections for subsidized housing requiring notice. So there's no gotcha element here, but Ms. Smeltzer knows that she needs to keep her nose to the grindstone, and she's working on getting back to work and recovering from what happened. And this is a chance to preserve her tenancy and get back to work after all the stuff with Mr. Jones in particular.
Ms. Smelser, did you hear everything that was said?
Yes, sir.
And do you agree with those terms and conditions?
Yes.
All right, so 6 months from today would be December 15th. I think. July, August, September, October, November, December 15th. December 15th is a Friday. We'll just go with that. It'll take a day or two to do the order. Do you understand? Now, was there an issue with pets? So
There was an unauthorized dog to our knowledge at the unit multiple times.
And there are to be no pets.
There's a no pet policy, yes.
You understand that, Ms. Smeltzer? No pets.
Yes.
You understand?
Yeah.
No unauthorized repairs. Somebody changed the toilet, somebody did some drywall repair. Someone kept on disconnecting the smoke detectors and there was evidence of smoking in there. So no smoking and no disconnecting all of the smoke detectors. Understand?
Yes.
Your Honor, we believe there was an issue with faulty smoke detectors, and that through cooperation between the parties, we've resolved.
All right, well, disconnecting them a couple times isn't the solution to that problem, getting the people to fix them. But anyway, don't disconnect them. If they're malfunctioning, contact the office. The last thing we need is a fire at Riverside Townhouses. No unauthorized inhabitants. I'm inclined to add a condition of Michael Hosey Jones is not allowed to come back there.
I believe he's incarcerated, isn't he, Your Honor?
Well, let's see, he was.
He's in prison.
All right, so he's not an issue. Mr. Chris was also incarcerated, but I think he got out. All right, well, we don't have to worry about him then, good.
Your Honor, just to put the citation on the record.
Yes.
Completely, under Michigan Code Rule 2.602C, subparagraph D, allows Ms. Smeltzer to file a verified objection to any allegations. Allows her 14 days to file a verified objection. Notice to my address as counsel.
So if there's a violation and they want to do an immediate termination, she has 14 days to object.
That's right.
And then we have to have a hearing after that.
If there's an allegation.
If it's objections filed, judge, like,
Okay.
yeah, under it would be 4A under the conditional dismissal that.
All right.
Yeah.
All right, who's gonna do the order?
We're gonna do it together, Judge.
Okay.
I'm sure.
What's that? Attorneys are control freaks?
I don't mind, as long as you guys are gonna do it, that's fine with me.
We seem to be working together, which is.
Ms. Smeltzer, had you been evicted from these premises, it would have been difficult or impossible for you to find other subsidized housing. Absent the issues with Mr. Jones and Mr. Christ, from the pleadings that I saw, had we had a trial, if they sustained those pleadings, there would have been enough to terminate your tenancy 10 days from now. Sometimes you don't know what you got till it's gone. So you've got 6 months under this conditional dismissal order to stay within the terms and confines of your lease and maintain your tenancy. If it doesn't happen, we'll have a hearing regarding the termination of your tenancy, and this would go on your record. If this is conditionally dismissed, there won't be any record of that. Do you have any questions?
No.
What is the rent here?
$16. Let me judge, if you give me 1 second, I can.
The rent varies based on the tenant's income.
Right, it does, but I thought I had a bunch of.
Your Honor, I can tell you, prior to the incidents with Mr. Jones, Ms. Smeltzer routinely paid over $200 a month.
But I just was concerned whether there's any rent arrearage we need to be concerned with.
Yes.
The rent's currently $18 a month, but I've been paying $69 every 2 weeks to pay some maintenance fees as well.
Our rent is $18 a month when we shouldn't be able to get in arrearage problems with that. And one more reason to maintain this tenancy. All right, Ms. Smeltzer, do you have any questions?
No.
Does anybody else have anything they wish to place on the record?
Judge, it looks like there was a balance of $511 back in March, so I would just ask Ms. Smelter to reach out to management to make sure that the balance, that she's current.
All right.
They were maintenance fees, and I've been paying on those.
All right. All right, this completes our day, I guess.
Your Honor, may I inquire of my,
Yes, certainly.
Ms. Smelter, are you entering this agreement voluntarily?
Yes.
Is anyone forcing you to enter it then?
No.
And you understand you're giving up your right to a trial on the substantive allegations in the complaint?
Yes.
Do you have any concerns about the representation you've received throughout the course of this?
No.
Okay, thank you, Your Honor.
All right, Ms. Zanin, anything else?
No, Judge.
Well, now you can remember how to get to Centerville. Ms. Bauer has to come down here every once in a while, but it ain't on the way to anywhere else. All right, Ms. Smeltzer, you're good to go. Hopefully, I won't hear any more about this, which would make me very happy.
Thank you, Judge.
Thank you. I'll stop the record.
This man admitted to dumping his cousin's dead body, was charged with obstructing at that time, and said she died smoking marijuana with him, so he panicked and dumped her.
Okay, and just to let you know, Mr. Brazier has two matters. I'm not sure if you're appearing on both, counsel. And I want to let you know there is a suppression order on one of the matters. So I want you to be aware of that as well.
I understand. I represent on both matters, Your Honor.
Okay, we're going to handle them one at a time. First, we're going to handle the matter that it's a warrant status for failing to appear for a review date. Mr. Brazier, state your full name.
Jalen Brazier.
And this is case 1904611 People State Commissioner is Jalen Omar Brazier, also known as Jalen Brazier, appearance for the people.
Nobody on behalf of Mr. Brazier.
Thank you. For the people? Oh, you're fine.
Steve Vincent for the people, Judge.
Thank you. As to the arraignment on this matter, counsel, Mr. Dottie?
We're going to wait for more reading of the record. We don't understand you.
Thank you, sir. And on this matter, court waive formal reading. As an adjudicated matter, a review date will be scheduled. Mr. Brazier and counsel, on this matter, a review date scheduled via Zoom, August 14th. That's a Monday, 8:30 via Zoom, 36th District Court, Judge Bryant. Court recall warrant set aside KP Center plea of not guilty from anything as to bond on this matter from the people.
The people, Judge, are just requesting a personal bond. This is a retail fraud. It happened about 3.5 years ago. We looked into the history regarding these types of issues. We're comfortable asking for the personal bond, no contact whatsoever with, I think it's Myers, Judge. So we'd be asking for no contact whatsoever with any Myers.
Thank you. Any response, counsel?
Well, Your Honor, we accept the question for the personal bond.
So this is an adjudicated matter, Mr. Brazier. You're going to receive a review date. Court's following a recommendation from both parties. You are going to receive a $10,000 personal bond with the following conditions. During this bond, sir, you are not to use any illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. And do not go to the area or premises of 1301 West 8 Mile. That's in Detroit, Michigan, at Myers. Is that understood? Do not go anywhere near that area or premises. Okay. And then again, you have a personal bond on that matter. A review date's been scheduled. Mr. Brazier, you have an additional felony allegation, sir. State your full name again, please.
Jalen Brazier.
Thank you. And this is on case number 2305739, People State of Michigan versus Jalen Omar Brazier, appearance for the people.
Good afternoon, Your Honor. Ryan Elsey, appearing for the people. My P number is 81329.
Thank you.
Nobody on behalf of Mr. Brazier. P number 75614.
Thank you. And as to the arraignment, counsel?
With the formal reading of the record, my client can mute, Your Honor.
Thank you both. Court will waive formal reading, enter a plea of not guilty. Scheduling 2 court dates, Mr. Brazier. You must attend both. You have a probable cause conference via Zoom, July the 3rd. That's a Monday, 8:30, 36th District Court, Judge King. You have a right to a preliminary examination July 10th, the following Monday, in person at 1:45 p.m., 36th District Court, Judge King. July 3rd, via Zoom at 8:30, July 10th, in person, 1:45 p.m., Judge King, 36th District Court. Not guilty plea is entered in anything as the bond from the people.
Yes, Your Honor. In this case, the people are requesting that the defendant be remanded pending trial. As the court knows, under Article 1, Section 15 of the Michigan Constitution and the accompanying court rule, bail can be denied in a murder case where proof is evident or the presumption is great. And in this case, there is a compelling body of evidence that confirms that the defendant took a young woman's life, disposed of her remains, and then repeatedly obstructed the investigation into her disappearance. And that evidence in and of itself shows that he poses an extreme danger to this community. Just to summarize the evidence briefly, we are here because Zion Foster, a 17-year-old girl, and the defendant, her then 23-year-old cousin, walked into the defendant's...
There is a suppression order. I just want to remind you on suppressing any, well, I'm sure you read it from your office.
No, I understand, Your Honor, and we did move to suppress the warrant once it was entered into the system, just so that there wouldn't be any interference with the arrest. But I do feel the need.
It also indicates suppression of the investigator's report, as well as the warrant information and witness list.
I understand, Your Honor, and I guess if the court doesn't want me to dive into the facts.
No, I just want, you can put what, I apologize to cut you off. You can put what you like. I just wanted to remind you of the order, to be cautious to not violate it.
Okay, Your Honor.
Okay, but proceed however you like.
Very, very well, Your Honor. So there obviously the court has reviewed the investigator's report. There's a compelling amount of evidence in this case, circumstantially, that supports the conclusion that the defendant killed his cousin and then disposed of her remains. I guess in light of the order, I'm not gonna go into any vivid detail as to the nature of the evidence. If the court has specific questions, I'm happy to address them. But in addition to that, I think as the facts are laid out in the investigator's report and the overall circumstances of this case illustrate that the defendant poses a danger to the community. I think that the disposal of a human being into a dumpster, illustrates the regard that this particular defendant has for human life. Again, when you look at all of the forensic evidence in this case, it is compelling. And in addition to that evidence, there are some factors that I want to highlight when it comes to concerns that I have with the defendant's flight risk. And number one is that, from my understanding, the defendant has significant out-of-state contact. He did reside in Texas for a period of his life and accumulated various criminal contacts in the state of Texas, including being implicated in various petty offenses as a juvenile, some of which my understanding is resulted in juvenile dispositions. Secondly, he is currently on parole for lying to investigators in Macomb County in connection with the investigation that gave rise to this case. My understanding is that during the course of his parole, he has inquired with the Michigan Department of Corrections about relocating to the state of Nevada. Third, he is facing a tremendously high potential sentence in this case, especially given that sentencing can run consecutively when it comes to the tampering charge and the murder charge. I have his guidelines on the minimum end of the tampering charge. Again, this is the minimum end, scored at 34 to 67 months. And the minimum end of the murder charge scored at 225 months to 375 months to life. And I think that any time there is a sentence that potentially that high, there is a risk of flight. And the other concern that I have is that, as is laid out in further detail throughout the course of the investigation, the defendant has a proven track record of obstruction in this case. Obstruction in the form of making evidence disappear, obstruction in the form of false statements, and given the overall circumstances of this case, given the defendant's contacts with other jurisdictions, he's not only a flight risk, but he's a danger to this community and a danger to the very integrity of this investigation. And because of all those factors, I would ask for him to be remanded.
So I've kind of been following this case just a little bit, and because I like true crime, and it kind of interested me when I first heard about what he did, and that they didn't charge him right away. I was kind of shocked, and then now that they are charging him, I'm not surprised. I don't know what evidence they have. It sounds like there's a suppression order. Hopefully soon we'll find out. I will say this, I'm not surprised they're charging him. I always thought that he killed his cousin. The story that he told to family members was that they were smoking marijuana and she suddenly died. And then he didn't know what to do. He panicked and dumped her in a dumpster. So that's the story that he's told people.
Thank you, APALC. Any response, Council?
Yes, Your Honor, we're asking for a personal bond. As far as the allegations of being a flight risk, I'll go in reverse. I think context as a juvenile in the state of Texas does not make a criminal nature and a network that he can go to. He does not have the means to go anywhere. He just started a job a month ago. He lives with his family. He has a wife and 2 children here. He is not a flight risk at all. He doesn't have the means and he doesn't have anything necessary to go anywhere, let alone out of the state of Michigan. As far as the danger to society, I would argue that is not true. He has been on parole. He served. He had 2 instances where he did not tell the truth to a detective in East Point, Michigan, and he made a plea. And he served his time in the correctional facility for those charges. Those are the only times he's allowed to investigate. Okay, there's not a multitude of lies. He served his time. He's on parole right now. He's been on parole for 5 months. He's had no problems with it whatsoever. In his job, he goes to work. He goes home. He goes back to work. He goes home. That's all he does. He doesn't go anywhere. His grandmother.
The lies were about this case, just so you know. He lied about this case. He first told the police he hadn't seen his cousin in years.
Comes and visits him and his children. He is not a threat to society, nor is he a threat to leave. He's been a model parolee in this situation. Okay, so to say that he has all these things and he's this huge, vast criminal empire and he can go and leave the country and go to Argentina and not face extradition, that's simply not true. Okay, they're painting a picture of a person who is not in front of you today. Okay, as far as what happened, I believe this is at least the 3rd time the prosecutor's office has tried to bring charges against my client for the disappearance and alleged murder of Zion Foster. And they've been told multiple times, you do not have enough evidence. Now, I don't know what they have today that has changed that, but it can't be as compelling as anything before because they've been denied. They've been denied to bring charges on multiple occasions by the prosecutor's office. So again, I don't know, and I have just got into this today. I just found out about this hearing today, not even 10 minutes ago. So I haven't seen any of the evidence or spoken about. I haven't seen any of the reports. I haven't even known anything was suppressed until you spoke to it today. But he's painting a picture of a person that doesn't exist. And actually, when I represented Mr. Brazier in Macomb County, he's actually one of the smartest, most articulate persons I've ever met. He's not some criminal. He's not some murderer. They've never been able to show it. And one of the mistakes that were made by the court was ignoring evidence that didn't disappear. They just let out and ignored it. And they were unable to bring charges. Now, then I'm going to find out through discovery what has changed to this point where they think they can make allegations of sexual abuse against my client. So therefore, we're asking for a personal bond, Your Honor.
Thank you. Any response from, go ahead.
He'd like to get back to work. It took him over a month to get the current job he has now. He's in financial despair to take care of his whole house. He's had to move. I found out just this afternoon that the Detroit police came in the door of his home while nobody was there. Searched his home, ransacked it, took items, including a computer that's not his, left a note on the couch telling what they took, and I believe a copy of a search warrant that I haven't seen yet. I mean, being on parole, he may or may be subject to a warrantless search, but I'm not sure kicking in his door when nobody's home to search a home, ransacking it, allows that even on parole for parole.
That's true too. They have tried to charge him multiple times, and yeah, we'll see what they have this time.
But again, 5 months on parole, not a peep out of it, man.
Thank you. Any response from the people?
Your Honor, just a couple of points I want to make. Number one, about the reference to charges supposedly being denied at various points. This case was the result of a very lengthy investigation, an investigation that was made lengthy by conduct by the defendant's own admission that he disposed of the victim's body, which was never found. In any situation where we're dealing with the lack of a body, there's going to have to be a lot of investigation and a lot of time put into the investigation, and that's what got us here. But at the end of the day, we have a situation where the defendant and his younger cousin, who was 17 at the time when he was 23, walked into his house late at night, and she came out dead, was put in the trunk of his car, and he disposed of her body in a dumpster and then gave a series of inconsistent and largely unsupportable claims about what happened. So this idea that this is just some innocent person standing here is not going to be bared out by the facts that get presented in this case. And for that and for all of the information that's laid out in the investigator's report, again, I would stand by the request for remand. Short of that, I would ask for a high cash bond with a GPS tether and a house arrest. But I believe in these circumstances that remand is the only appropriate bond.
No bond.
Right.
And I'm going to let you know that I think this is the king here. I hope that that you guys agree with me in this case, but I don't know. Maybe I'm wrong. I'm wrong half the time.
Thank you. Anything further, counsel?
Yes, I agree with the tether. I don't have a problem with that. As long as he can go to work and go home, we have no problem with that. He's not, again, a threat to anybody. He's not a threat to society. And to say that these charges took so much investigation, well, then they jumped the gun on multiple other times to try to get charges brought forth, and they were not able to. And to say that he stopped this investigation, well, this is a 2022 case. You know what stopped this case? The Detroit police not doing their job, period. And that's not anything my client did. He did not find the body. Yes, he did dispose of it. He made Your Honor, to say he murdered her at this point and to hold a bond based upon a murder that did not occur, it's irresponsible, I believe.
Your Honor, can I make one response?
Sure.
The idea that the Detroit Police Department did not do their job is frankly offensive, given that it's been publicly reported in this case that officers of the Detroit Police Department risked their own health to dig and dig and dig through a landfill in hazardous conditions for months.
Okay, let's keep it to the purpose that why we're here. Okay, gentlemen, let's keep it to the purpose why we're here. I want to hear stuff regarding bond, and I appreciate both of your arguments. Anything further, APA?
No, Your Honor, thank you.
You're welcome. Anything further, Council Ben?
Oh, yeah.
Okay, thank you both. Mr. Brazier, the court heard advocacy from arguments from both parties. Your attorney has advocated very well on your behalf. The court takes into consideration a number of things. I've had the opportunity to review the investigator's report, and it is extremely concerning. These allegations are of the utmost serious. Specifically count one, which is a possibility of a life offense where the allegation is somebody lost their life in reaction in relation to your actions. The court has considered very concerning that you were on parole for a conviction while at the time of this allegation, as indicated by APA-LC. These are very serious pending allegations, and taking into consideration your prior criminal record, as well as the parole status and the serious nature of these allegations, the court, Mr. Brazier, does find you to be a danger to the community and finds that releasing you on a personal bond or any bond will not adequately satisfy the public's, not adequately protect the public safety, finding you to be a danger to the community, given the information alleged in the investigator's report as well as provided by APA-LC. And for those reasons, the fact that you are on parole at the time of these allegations, the serious nature as indicated of the charges, specifically count one, as well as the information throughout the investigator's report, the court finding you to be a danger to the community is remanding you into custody for further proceedings. Anything further from the people?
No, Your Honor, thank you.
Anything from defense?
No, Your Honor, thank you.
Okay, good luck to everybody involved.
Thank you, Your Honor.
Have a good day. Thank you both. Please, Your Honor. We'll meet you on the female side.
Okay.
We have a time now.
Here come the ladies. Men. Dating material coming your way. Swipe right. Swipe left.
Thank you. Your name, please?
Chelsea Smith.
For 1 moment.
That volume is not me, you guys, just so you know.
And Ms. Smith, regarding case 2305731, people state of Michigan versus Chelsea Page Smith, identified in the complaints defendant 2, also known as Chelsea Smith, appearance for the people.
Thanks, Judge. Good afternoon, Steve Edson for the people.
And Ryder Rock, PA 3665, Chelsea Smith, waive reading, stand mute, Ms. Smith, been advised to the right.
Thank you both. Court waive formal reading and her plea of not guilty. Ms. Smith, the court scheduling 2 court dates, ma'am. You must attend both of them. You have a probable cause conference via Zoom on Wednesday, June 21st, 8:30 a.m., 36th District Court, Judge King. You have a right to a preliminary examination in person, June 28th, the following Wednesday, 8:30 a.m., 36th District Court, Judge King. June 21st, June 28th, Judge King, 36th District Court. Understood, Ms. Smith?
Yes, understood. Can you explain to me why do I have, is that three to 4 different court dates or 2 different court dates?
Are you paying attention, Ms. Smith? Where do you get 4
Yeah,
court
he was
dates come from?
talking.
Do you want me to address that?
Hey, Ms. Smith, you're gonna get paperwork with all your court dates when you leave, and we're gonna either reach out to you, get you signed up for tax surrenders, we're gonna have everything. I really don't want you to have to answer any questions on the record. We can talk to you when this is over with, okay?
Okay, thank you.
Do you mind if I give her the court dates again?
Go ahead.
Okay, and so Ms. Smith, I've only given you 2 court dates, and it's June 21st and June 28th, 8:30, 36th District Court, Judge King. A week from Wednesday, they're both on a Wednesday, June 21st, June 28th. Understood?
Understood.
Thank you, ma'am. Not guilty. Please enter on your behalf anything as a bond from the people.
Judge, this is the second of 2 defendants we previously spoke of, as the people ended up mentioning. Your Honor, in this particular instance, prior to what defendant 1 had alleged allegedly done, firing shots as well as fleeing from the police and urinating on the police car. What happened prior to that was defendant 1 allegedly ended up reaching the residence by her vehicle that she was driving, and then she attempted to try to run the victim over with her vehicle. Fortunately, allegedly, Judge, she ended up missing that individual, but she struck a tree. Now, the interesting here, the unfortunate thing here that people should say, Judge, is there were 2 small children in the vehicle while the defendant was allegedly doing this. As well, Judge, I'm sure as Your Honor ended up seeing in the investigative report, even though there isn't a charge for intoxication here, for whatever reason, there was a test that was given. We know the reason why the test was given, but for whatever reason, there wasn't a charge. But apparently, the defendant ended up blowing close to a 1.9 for her intoxication. Now, Judge, here's something else that
close to a 0.19, not a
0.19. Oh, I'm sorry.
No, it's good.
Well, Judge, this particular defendant right now has multiple traffic offenses going on, having to do with a motor vehicle, having to do with leaving the scene of an accident after property damage, having to do with driving a vehicle while her license isn't valid, having to do with an accident failing to stop, and improper plates. Now, Judge, here we have this gal who allegedly did all of this while she was driving a vehicle, doing it unlawfully on the roadway, doing it when she didn't have the license to support the vehicle. And Your Honor, people, just one other thing, the victim involved in this matter allegedly ended up recording a conversation between the defendant and herself, where this defendant allegedly threatened to kill her. And allegedly, Judge, that is recorded. I think where it says that she ended up recording a conversation that said the defendant was telling her that she would kill her multiple times and she didn't care about going to jail or not. And Your Honor, I did it again, and I apologize, and I should have told you what the people were asking for. The people would be asking for the same thing as defendant 1. We would be asking $1,000 cash, no surety, as well as GPS.
Thank you. APA, any response?
Yes, Your Honor, Ms. Smith is 28 years old. She's a white resident here in the city of Detroit. She has no prior criminal convictions in the traffic matters, no pending matters, no probation, no parole in the traffic. She's not employed. She indicates she's unable to post a monetary bond. She's a high school graduate. She's also a trade school graduate where she's received a certified trade as a medical assistant. Your Honor, the charges on her face are very serious, and they're assaultive. I understand that. But we're not, looking at this report, determining how bad the allegations are and punishing her with a bond. This is about whether or not, Ms. Smith deserves to be in Wayne County Jail until she gets her next court date, or whether or not she's going to be able to raise her 3 children while this case is pending. Now, Judge, with somebody with no priors, no KPS history, nothing besides traffic history that's really being mentioned here, I think personal bond's appropriate. The court could go an extra step further. I understand that there's maybe allegations of threat. The court wants to go a step further and do a tether here and restrict no contact order. She's not employed, Judge, so she could be at home. We could do a home confinement here. This is an FHR. It's still serious, but it's not a GBH. It's not an English. I believe if we were to sentence her her guidelines would probably be somewhere between 0 and 17 months, meaning a presumption of probation. When you get down there at the circuit court level, we're going to do this as charge. We're only firearms charge here. She's not the one like this. I'm not saying the allegations on her are okay or acceptable or that we're getting to them. But if the court wants to go as far as the home confinement and ensure that she doesn't get in the vehicle, I think that may be appropriate. I just ask the court not set a cash bond here. This is a mother of 3, Judge, and I don't know what exactly would happen with the children, or any livelihood that she may be able to provide them. I believe she's a full-time mother. I think bond, personal and home confinement, any conditions like no driver would be appropriate. I just ask the court not to set a cash bond.
And I'd like to hear from both parties. And this is where the court sits. Where the concerns the court has, it was highlighted by APA Vincent, not only regarding the nature of this allegation, attempting to hit somebody with a vehicle, that's extremely concerning, and then crashing the tree. Very also concerning is the allegation that she had minor children with her. But then I would like to hear any or addressing that. After that fact, it's alleged that, and it was alleged to have been recorded that she called the complainant threatening to kill her a number of times, also indicating that she allegedly did not care about going to jail. And that's concerning. That these are just allegations, but not only do we have an attempt on an individual's life that with minor children in the vehicle, but then subsequently it's alleged, ma'am, please, it's alleged that she called multiple times threatening to kill her and not caring about consequences, basically. So that's where the court has the high concerns.
Your Honor, can I please?
Hold on, Ms. Smith. Hey, I promise you, I know what I'm doing.
But I don't listen.
Just hold on. I know, it's okay. Judge, with regard to Ms. Smith, I gotta shed some light on this dynamic. She is, I believe the current girlfriend of defendant one, who the other party was defendant one to help from. There's already some sort of resentment here. There's already a dynamic, Judge. Now, that's why I think it probably would be appropriate. But with regard to she's calling and she said this and she said, I just don't know how credible any of it is until I really listen to it. You know, this
was alleged to have been recorded.
Right, I've seen a ton of other things like that been recorded too, Judge, I promise. And there's other times that they make their way into the trial court. Nonetheless, though, without that evidence is just being stated in the report, without me seeing it, I can't really comment on it. But I think the court's concern here is threatening in contact, and that can be addressed without tact.
Well, multiple threats and an attempt to run somebody over with allegedly in a vehicle with minor children, and there was apparently damage to a tree, injuries to the victim, tire tracks in the grass on the sidewalk, and a vehicle against the trees, what I read in the investigator's report and evidence, while attempting to hit somebody with the vehicle. And then on top of what I have concerns with minor children in the car. So yeah, I have concerns.
Obviously, that's not charged. You know, when I gotta bring it up, there's no child endangerment charge here. There's no OWI charge.
No, but it's something I take into consideration.
Absolutely.
May the people just say.
Absolutely.
And I can see where the judge is going with this, but just to justify all of this, there seems to be an escalation here because the ongoing cases regarding using a car and getting into an accident, taking off and not stopping, and now we have using a car, allegedly attacking an individual, hitting a tree. It just seems like there's an escalation here, and unfortunately, this defendant's weapon of choice is a vehicle. And now we have her allegedly going after an individual. Quite honestly, people would be asking for more than the $50,000, but for the fact that there aren't any priors and she isn't on parole or probation.
And she just has, she's charged with the one felonious account.
Right, Judge, as well as this.
Right, I understood. Okay, thank you. And the court, anything else from either party? Thank you. Yeah, go ahead, counsel.
But if defense counsel talks to people, would like to reserve the right to respond.
No problem. I'm inclined just while you look up whatever you're looking up on your phone.
The only thing that I'm left with to say is these, I don't know that these.
Thank you.
No, they have. They're ongoing.
Okay. So absolutely. I'm sorry to cut you off. Anything else? Okay. So Ms. Smith, you have no previous history or criminal convictions less than a place on the record, no allegation of assault, no criminal convictions the court's aware of. Your unemployment status as released, ability to post bonds taken into consideration. You have ties to the community, and that's all advocacy from your counsel, who has done a great job as always on your behalf. And the court takes into consideration information you provided. Where the concerns lie, and I placed on the record more than once, and it's been echoed by APA Vincent, is an allegation that you attempted to run people over with your vehicle. Allegation is then that you had small children not secured, 2 small children not secured in the seats while you were allegedly attempting to run people over with your vehicle. Assault individuals while you allegedly had minor children in the seat unsecured, which you resulted in allegedly hitting a tree again with your minor children allegedly in the car unsecured. It's an allegation that you had an extremely high blood alcohol content and that's concerning. And then that's the allegation on the date. And then the court has the concerns as stated that follows. Following, it's alleged that after those allegations, you reached out proactively, according to the allegation investigators report, threatening to kill multiple times, threatening to kill the complainant, brazenly, allegedly, not caring about going to jail, and saying you were with your cousins. This is very concerning to the court. There's a likelihood of conviction regarding allegations of damage to the tree, tire tracks in the grass and the sidewalk, pictures of injuries to the victim. We have victims' allegations and statements. And for all of those reasons, Ms. Smith,
We've been hurt by each other. Listen, Your Honor, I never intended to try to hit nobody. They pulled me.
I'm your attorney and I'm advising you to stop talking.
What was that?
I advise you to stop talking and I believe you should call them.
And I think you've advised her more than once. So, Ms. Smith, for those reasons, the court finds you to be a danger to the community, as well as the complainants, your small children, and according to the allegation investigators report, we're finding a personal bond will not adequately protect the safety of the complainants that you allege to have called and threatened and not caring about consequences after the very concerning allegation of you attempting to hit them with your vehicle. For those reasons, the court setting an intentional unaffordable bond, and you'll have an unaffordable bond redetermination hearing 2 days from today in front of Chief Judge McConnell, June 15th. That's Thursday, 2023 at 9 a.m. via Zoom. Only if you're unable to post bond, you attend that court date. If you're able to post, you do not need to attend the June 15th. You'll always need to attend the June 21st, June 28th. Given the concerns the court's placed on the record during this bond, which is going to be set at $50,000, 10%, you're not to use any alcohol, no illegal controlled substance. You're not to assault, harass, intimidate, beat, molest, wound, threaten any minor children. No assaultive contact with any minor children. Absolutely no driving, period. Absolutely no driving, period. You are going to be fit with a GPS tether prior to being released. If you're able to make bond, they'll be under house arrest. You're to go to your home, wherever that is, not near the Chalmers address, and remain there until told otherwise by a judge, under house arrest if you're able to post. Do not go anywhere near the area or premises of 5789 Chalmers, Unit 1 in Detroit, Michigan, 48213. No contact with the complainants, Antonio Destin Johnson, and no contact with Stephanie King. That's no contact of any kind. No contact orally in writing through a third party at their place of residency, employment, or through any forms of social media. Absolutely no contact with Stephanie King or Antonio Johnson. Anything further from the people or the defense?
Nothing further.
Okay, good luck, Ms. Smith.
I have one request. My ID, my social security card, my wallet, and my phone is inside my vehicle, and along with my money is inside my vehicle. So, like, all I ask for you is when I go to the tow truck places to get my belongings. I never was gonna retrieve the vehicle. I just need my belongings out of the vehicle, which is my ID, social security card, my money, and my phone, and my wallet.
Okay, I'm not, Counselor, do you know what she's asking?
She wants her social, her identification.
I don't have it.
I think the court has.
No, we don't. Counsel, anything further from either party? Anything? I mean, if you have property in your vehicle and it's your legal property and the people want to give it back, it's not being held pending investigation. If you have a legal right to it, I have no problem with you getting it back. Anything further? Okay. Good luck, Ms. Smith.